Hello there and welcome to Evolving Project Delivery, Mastering Change with AIA Contract Documents. This is a webinar brought to you by AIA Contract Documents powered by Katina. Before we get started, we're going to do a few administrative items and the first initial slides. Tom, can you advance? So this presentation is protected by U.S. and international copyright laws. Reproduction, distribution, display, and use of the presentation without written permission is prohibited. Next slide. This is a disclaimer we include in all of our AIA Contract Documents webinars. The information presented today is not provided as legal advice. We always recommend that you confer with your legal counsel. Next. So this program is registered with the AIA for one continuing education learning unit. When you registered for this program, you entered your AIA member ID if applicable. We will use that information to report your credit in the next 10 business days. So it will appear automatically in your online transcript. So Tom, if I may, I'm going to turn it over to you now to discuss the learning objectives, and then our presenters are going to introduce themselves and get started. I do encourage the audience to ask any questions in the chat. Time permitting, at the end of the presentation, we'll answer as many questions as we can. And you will receive the PowerPoint and the recording of today's session via email in the next 2 business days. Tom, take it away.
Thank you, Hasti. Good afternoon. Our objectives are fairly straightforward. We're going to review the document structure for AIA's contract documents and review a bit on the family of documents and how they relate to each other. And then there's some new documents that are coming out that we're going to describe on more of a collaborative project delivery method based upon the CMC documents. And then also to become familiar with the resources that we have for continuing to learn about the documents. Mike?
Thanks, Tom. My name is Mike Bamba. I'm a Managing Director and Counsel with AIA Contract Documents. I've been with the Contract Documents team since 2006. I think that picture is probably from 2008, but you've got our images, so you see the real thing. I've worked on a number of our documents, starting with the owner architect agreements, doing all of our IPD agreements, which was going to be relevant to this presentation. So I've been working with the committee for a long time now, and looking forward to discussing these documents. Tom?
Thank you, Mike. Tom Heisel. I'm a principal at a Minneapolis-based architectural firm, Alliance. I work a lot on project management, large projects, and I've been on the documents committee for, I think, I'm in my 8th year now, and kind of working on the project management side and firm management. Pat?
Thanks, Tom. I'm Pat O'Connor. I've practiced law for about 40 years now. Like Tom, I'm based in Minneapolis, and I'm with my own firm now. Before that, I was with a fairly large firm that had offices around the world. I have been associated with the AIA, I think about a year or 2 after Mike became associated with the AIA, back I think in 2007. I am currently outside counsel to the AIA Documents Committee, and I have practiced construction law and have written a fairly lengthy construction law treatise. I'll flip it back to you, Tom.
And we'll give it over to Mike, who's going to take us through the contract documents in the committee. So this actually, I'll just hit it real quickly. This is the agenda relating to the learning objectives that we talked about. The first one we'll talk about specifically is the documents committee by Mike.
Thanks, Tom. Yeah, the bulk of the presentation will be talking about our new collaborative CM documents, but we did want to provide a little bit of history on the committee and then set the stage for how we ended up doing the collaborative CM documents. But in terms of history, the AIA Contract Documents program has been around for a long time. It's actually 136 years now. We need to update our slide. We've been doing it for a long time. The construction industry, though, has changed significantly in that period of time. I think the first agreement in 1888. The uniform contract was 3-ish pages long. I think our average, the A201 is for 40 something, some pages long. So we've, the complexity of the industry has grown, and so have our documents. One of the unique things about our program, because of the longevity, is there is a substantial volume of case law, which has led to the AIA Legal Citator being published. And our library has grown from the single document to over 240 agreements and forms. Our objectives in the Documents Committee program has always been the same, and that's to be the industry standard and to provide standard form agreements that are fair and balanced for people to use as starting points as they negotiate contracts for their projects. We're always trying to balance competing interests, but that means making decisions on where risk should lie, and our guiding principle in that arena is to put the risk in the place where it can best be managed. Now, frequently that's with the party responsible for the service. So, architect be primarily responsible for the design, the contractor is primarily responsible for construction. The owner purchases the land, and so they're responsible for the land. And obviously, if there's an insurance policy in place that the parties can purchase, we'll place the risk with that insurance policy because that's what it's there for. Our drafting process is detailed, we'll call it. I think the A201, we update the A201, the general conditions document every 10 years, like most of our documents, but that's our flagship general conditions. And the drafting process for that will take approximately 3 years from beginning to end. And the process is always the same for all of our documents. We are constantly researching legal decisions to see what has happened in the interim from when we release a draft to when we revise it. We also go through the process of constantly seeking industry comments and feedback, investigate the impact of legal decisions and practice changes in the industry in the 10 years that a document is out. And then we begin the drafting and revision process. And the drafting and revision process will take a number of years. It'll go through a few iterations where we'll draft, we'll send a document out and solicit feedback and review from not only our own documents committee, but outside of the documents committee with industry experts. And then we'll go through the finalization and publishing. And then we start it all over again, monitoring those documents as we work on drafting other documents. So who participates in this drafting process? Again, the core is the AIA Contract Documents Committee, and then the AIA Contract Documents staff, and then people like Pat, like our outside counsel. But we also do a lot of market research in the industry. We also reach out to a number of other industry stakeholders. We're very active in the American Bar Association Construction Law Forum, which has a number of divisions that focus on different participants in the construction industry. For example, there's a division for owners, attorneys who represent owners, contractors, and architects, as well as subs, and a few other relevant divisions. The American College of Construction Lawyers is another frequent collaborator that we work with. And then we're always reaching out to construction and engineering industry associations. And that's in addition to individual experts in the industry. So those will constitute our liaisons and subject matter experts. But saving the best for last, the AIA Documents Committee throughout the course of the program has been the core drafters of the documents. The Documents Committee itself is comprised of 30 to 35 volunteer AIA members, all of whom are practicing architects. They don't all work at architecture firms. We try to get diversity of opinions amongst the committee. So while there's a requirement, because it is an AIA committee, that everyone be a licensed architect, many of our members are practicing at contractors or are working with owners in their official capacity. So we just try to get some diversity of opinion from there, in addition to our outside advisors. Pretty much every committee member serves a 10-year commitment, so it's a pretty long time. And I think that everyone who starts that 10-year commitment can't believe it's a 10-year commitment, and then by the end of their 10-year commitment, they almost all want to stay on longer. So it's a pretty amazing group of people. It's a pretty amazing process, and we can't get rid of them at the end of that 10 years. So Tom's at 8, so I expect an email pretty soon asking to stay on. Anyway, before we get into the new collaborative CM documents, I wanted to talk about the AIA document families of agreements, and we'll do this relatively quickly, but I mostly just want to set up how we ended up in the CMC world for our more collaborative documents, and it all starts with the conventional design bid build family, because I just want to focus on how this is structured, and this is the traditional way projects are delivered, right? The owner hires an architect designs the project, they go out to bid, and then the owner separately hires the contractor. So it's a very iterative process. You go through full design, then you bid it, then there's probably gonna be some value engineering, and then you build it, and then there's probably the last phase usually is secretly called the litigation phase. But you know, it goes through that linear process where the full design happens, then the contractor comes on board, then the contractor, although they've set their price, now has an opportunity to look at the design, you know, and there's limited opportunity for collaboration with the design team. So unfortunately, the party that designs it and the party that builds it have limited communications throughout the design process. Now, obviously, the traditional process has been in place for a long time. Most public projects are still done in the design bid build world, but it has its flaws, most of which relate to the linear nature of the project. And so a significant portion of my time at the AIA Contract Documents team has been implementing and trying to find more traditional, or less traditional and more innovative and collaborative ways to do projects. That culminated with we won't have a slide on this, but our integrated project delivery documents. 2007, 2008 timeframe. Everyone was very excited about the idea, but the implementation of that type of delivery model with extreme levels of collaboration, and waivers of claims, and things like that hasn't really caught on. So much so that Pat, with a little bit of my help, we wrote an article called IPD Part 1, and no one ever asked us to do Part 2. So, so the actual implementation of IPD hasn't really followed through. There's certainly areas of the industry that have done it, but it hasn't caught on wholesale. The idea behind our collaborative CM documents, though, is to take some of those IPD and collaborative principles and insert them in a more traditional set of documents that people are used to. But in the industry search for more collaborative documents, you have design build. We have a family for those documents. You can see the structure on the screen now. Owner hires a design builder. Design builder usually separately hires an architect and a contractor. So you can see from the owner's perspective, there's an idea of collaboration and integration because it has single source responsibility for the design builder. In reality, though, you know, the design is sort of, and the construction happens a level below the design builder, so they are removed from the owner. So you do lose a little bit of the full-on levels of collaboration, and the architect and the contractor that actually built the project are still under separate contracts and talking through the design builder, and the design builder is the one who's talking to the owner. CMA, again, this is in our vernacular as construction manager as advisor, where the owner hires a construction manager, but that construction manager isn't responsible for construction. So in this scenario, it's more akin to the design bid build process, where the owner and the architect hires the architect designs it, then they go out for bid for the general contractor or multiple primes. And the CMA serves an advisory role. So they are advising throughout the design process, but they're not the party who's ultimately responsible for construction. So while you do have a slightly more informed design process in terms of potential impacts on constructability and other means and methods, since it's a CMA and not the entity that will ultimately build the project, it still has a little bit less a collaborative feel to it, which then takes us to CMC. I think CMC inherently has the most potential for collaboration. think I've probably been hinting at it all along, in partially or mostly because the owner hires the architect and the party that is ultimately going to build the project early on in the process. And so instead of going through a design bid build scenario where you have full design, then you bid it, now the contractor's on board. The contractor who's ultimately going to be responsible for building the project is there throughout the entire design process, or at least significant portions of the design process, depending on how the timing of the contracts work out. So it's within that framework where CMC has the most opportunity for collaboration that we, when we were looking on ways to integrate more IPD-like principles into our standard agreements, that we started with the CMC documents. So with that background, I'll pass it off, I believe, to you, Tom, to get into our actual CMC documents.
Yeah, thank you, Mike. Mike set the stage perfectly for this. Over the years in my career, I've been started off heavy design build, and we all know the problems that are inherent within that, more adversarial. And over the years, and as public laws have changed to allow more collaborative CMC work and project delivery, it's starting to change the whole landscape of how we all work together, architects with owners and contractors. And the collaborative CM documents follow suit perfectly on that. And we started in 2019 where we updated the A135 and B135. And we spent, as Mike said, every 10-year cycle, and we finished that work. And coming off of that, then we started looking closer at the industry. And as Mike talked about, all our liaisons and how we work with the contractors and interviewing contractors, major big ones and small ones, and different entities, owners, and whatnot. We realized that, and from the practitioners too, document committee members, that the CMC documents focus really heavily on construction, and everything else is kind of the same in a way as it's always been, if you will. And so our intent here was to make pre-con more robust and more getting into we're all in this together. So we started taking, and that's a long title for a document that's on the screen. It's the A135, and actually it's 2024. It should be coming out in a few months. As Mike talked about the process, there is fine-tuning it as time goes on, but it will be released within a few months. Long title, but it basically is the CMC document that has been now designed for a collaborative project delivery. The cost of work plus a fee with a GMP. So it is very similar with a GMP. In the family with that, obviously, then is the architect owner agreement. Mike talked about the IPD documents, which IPD is a great concept. And how do we work together? What are the means that we can do that to be super collaborative? But in many ways, it didn't take off to the point where we had actually anticipated it in 2008 and whatnot. And so with that is we've started focusing more and more on how we can get the CMC documents, CMAR, CMR, depends on what you want to call it, more robust again. And so here are the documents. Again, the dates can be a little bit different, but they should be coming out soon. So the rationale on this is that it is building on the principles of collaboration, of how do we work together. And actually, I mentioned the three primary parties, the owner, the CM, and the architect, but also we are bringing in our consultants, obviously, subcontractors, suppliers, to bring in that expertise, to bring it into the pre-construction phase to really make sure that we all benefit through this enhanced collaboration. How can we continue building on that? So the documents are geared toward those who want to use CMC documents and really be engaged in it. It probably isn't for everybody, but It does have some of the basic IPD principles, such as waiver of claims and target costs and things like that. So there are things in here that are built in. Pulling straight from the document, here's the basic guiding principle. The architect, owner, and CM, not necessarily in that order, agree to plan, design, and construct the problem in a collaborative manner, endeavor to align individual interests with those of the project. We're all in this together. It's the bottom line. Together, we want to identify who we're going to work with. And obviously, this changes depending upon where the project is based, public or private. Are there bidding laws still within that? I have a major project going on in the state of Washington, which has on their what they call the GCCM delivery system, which is CM at risk, CMC. We still have to bid things out. The GMP comes at 90%, et cetera, complete CDs, et cetera. So, but again, the idea is that we're all, again, in this together, and I are identifying all these aspects as one. And one of the guiding principles for us working on these documents was not to be too prescriptive. Hopefully this document will be able to be worked for large complex projects as well as smaller ones. And within that, there are different ways to how to use collaborative tools and BIM and with that. And so the idea, and we'll talk more about that as time goes on, but who is setting the guidelines and how are we coming to agreement on what tools to use and how to use them? Going back to how Mike talked about how the committee is structured, especially in this, maybe I shouldn't say that, in all of ours, we're really pulling in our liaisons, but in this one, it was really interesting. It was bringing in the different owners reps with major developers, and we had different general counsels for the contractors, as we had mentioned, including then also, a major government institution that probably could be all capitalized too, to say how are you delivering projects? How do you want to work with your architects and contractors? And then the construction law attorneys, and on all sides of it, because they have different perspectives from the contractor side and from the architect side, and obviously from the owner's side. And how can we pull those in together? And so it was really good conversations and really helped craft the document. As Mike said, fair and balanced is our guideline. And how can we make sure that we're representing all these different parties as best we can and everyone's interest? So at the beginning, we were working with A133 and B133, and we're now comparing how those work. So here are some differences. The collaboration and use of BIM is one that's should be obvious by the time we're done with this webinar, but that is really important on bringing more elements of collaboration into this. The management of the project, there are really specific ways that are now built into the contract of ways to really work on the management from the different entities on it. Pre-con, again, that is the hallmark, what this document does with the new pre-design phase, which is more fleshed out and more detailed. And within that, we often come, architect comes with the owner, we develop all the project definition and things like that. The idea here is that we're coming in early, as what we're doing a lot in the industry with CM at risk. And together now we're working together to identify the goals. What are the success factors and risks that we have within this? So we look at the major components. It'll be the project management team, which is the day-by-day management, how the CM works in pre-construction, again, which was in the A133 was not really developed. We have other things in here about what are the requirements for the CM to review and comment. How do we handle what we call page turners or page-by-page reviews? Let's all make sure that we're reviewing the documents, working together, identifying risk, identifying opportunities, and we can bring value engineering into that, et cetera. We're going to touch a little bit on incentives in a bit, but that's idea of IPD, but again, with this, not trying to say here we're dictating how this goes, it's giving the opportunity for people to come in and define that themselves. And constructive meet and confer, Pat's going to talk a little bit more about that. We leave that up to the lawyers to talk about. And then with constructability, this is a lot of discussion was based on constructability. What is it? How do you define it? You know, is it going to be super helpful, or is it just, you know, hey, your reference here is missing, or you know, whatnot. So constructability is important for the project management team, which is again consists of the owner, architect, and contractor, to define and come in. What is it that you need? What is it that this specific project needs? So, what is the PMT? The PMT, as we're defining it now, is the project management team. And the project management team is to be identified with one person from each of the major entities here. And we didn't want to make it as, and through our discussions, it wasn't to be wide open and you have a conference room. It's 3 people who can make decisions mostly on the day-by-day management of the project and who are working together to achieve the mutual goals. With that is that the PMT, the project management team, needs to establish the protocols, even the communication protocols. It's always, again, something that if you try and dictate it, it's going to be, well, that's not right. And in this case, it's like, okay, you come in and you make sure that you're, you know, defining it together as one group. There are a couple points in here that we wanted to make sure that we're really clear. So the 2.1.2.1 and 2.2 want to make sure that this group is not the contractor. They're not, even though it represents the contractors on there, we're not responsible for means and methods, and we're not supervising the other entities' people. So we're really wanting to make that clear. The PMT, project management team, is more than boots on the ground. They're setting protocols. You know, they're setting what are the processes for your RFIs, for your, you know, ASIs. Co-location was talked a lot about in this day of Zoom calls, webinars, and how we can collaborate virtually. It's gotten really important to understand that maybe co-location, where we used to have the big room concept, is now different. And with that being different, again, we wanted to be this document to live it through its 10-year cycle and more. And so within that, have this PMT group define what that is. And again, it's important that we felt important that it's one person from the owner, CM, and architect. Pat's not going to take us through the CM during the pre-construction and other concepts.
Thanks, Tom. Let me see if I can back up for just a minute here. One of the things I seem to get I have an echo in this.
You're good, Pat.
Okay. No one else there is good. Well, one of the things that what we were trying to do here was to take a fairly well-known project delivery approach and infuse into that delivery approach a opportunity for the parties to act more collaboratively. The key to collaboration, or at least probably the groundwork for collaboration, is primarily communication. So what many of the changes that we've attempted to accomplish in this document is to make it possible and perhaps provide incentives for the parties to work more closely together with one another and to communicate more thoroughly with one another. But that's not to say that their roles are drastically altered from traditional delivery approaches. And the PowerPoint that you have in front of you kind of reinforces that. You know, this is essentially what we would call a standard of care type clause. It sets forth that the construction manager, at least during the pre-construction phase, is to perform its services with the reasonable care. It also makes it clear that the construction manager during the pre-construction phase is not a guarantor of any of the information that it's providing. It has to provide accurate information that parties can use and rely upon, but it does not necessarily guarantee that information. And the reason for that is because, you know, when you place a guarantee upon a party, then that party has to spend a lot more time and effort on the information. And at this stage, that's probably not appropriate. So, you know, there may be guarantees once the GMP, guaranteed maximum price amendment, is entered into, but not during this phase. And then the bold letter, which is not bold in the actual contract, you know, is making the point that I was just emphasizing. So, Tom, I think we can go on to the next one. So, what's the intent? You know, with regard to pre-construction, again, as I mentioned, it's to have the three principal parties, the owner, the architect, and the CM, to be working collaboratively throughout it. And so, like in any construction project, there's three variables that an owner is interested in. Well, frankly, almost all parties to the process are interested in. One is the cost. What's going to be the cost of the overall construction, cost of the overall project? What's the schedule? You know, how long is it going to take to get services, performed and the project completed? And, you know, and then the quality of the work. You know, so you've got cost, quality, and you've got schedule. And, you know, trying to marry those three concepts together requires a fair amount of communication. The cost estimating requirement really fulfills two purposes. One is to give a running account of how the costs are being affected by the design process, but also the principal effort is to make sure that there are no surprises. At the end of the day, contractual arrangements depend largely on the parties' expectations of what their contract their contractual arrangements are to provide them. And so the more that parties communicate, the more that those expectations are realistic and in line with one another. And so what we try to do in this instance is not have a situation where cost estimating is done at, you know, fixed intervals, but it's done more fluidly and embedded into the overall process, so that in some respects, while it may not be real-time estimating, the estimation process is a more organic process than you find in more traditional delivery approaches. Tom's mentioned the concept of constructability. And you know that in a traditional delivery approach, constructability is oftentimes assigned to people that have little or no deep experience in the construction process. It's oftentimes considered to be kind of an afterthought. What these documents try to do is to highlight and to bring more emphasis on the concept of constructability, because in actuality, you know, different designs can have significantly different effects on how the construction process proceeds and the cost and the timing associated with that construction process. And then finally, the page-by-page review with all the three principal parties is again another effort to try to avoid surprises, to try to align expectations. So if you're embedding the owner in the process of doing more or less a page-by-page review of the design as it's being created, it manages overall expectations, reduces conflict, and at the end of the day, results in a higher, with a better overall project experience for all the parties. Tom, we'll go on to the next one here. This PowerPoint really just emphasizes that in order for us to achieve what we need to achieve, we need to drive these contractual arrangements into the other agreements. In this particular case, you know, the contractual, the contractor owner agreement is coordinated with the undertakings of the architect in the architect owner agreement. And so there are corollary provisions in both those agreements. Okay, so more of the pre-design process. So again, as I mentioned before, in any collaborative approach, you want parties working together with, clearly set goals in mind. And so the first clause here talks about the fact that the three principal parties, the construction manager, the owner, and the architect, shall jointly develop a project definition. For the most part, the old traditional approach, the owner gave its project criteria over to the contractor, and the contractor essentially, had an opportunity to ask certain questions about it, and the design professional was tasked with trying to realize that, those criteria into an overall design, and then hope for the fact that the project can be built and the cost of the project can meet the owner's expectations. But it's not a collaborative process. You've got each party working in their own set sphere without a lot of communication. Here, you've got all three parties working together to define project definition, to have a conversation about that, so that at the end of the day, they're all on the same, wavelength, and all their interests are aligned as much as they can be aligned with regard to these undertakings. So, the last clause here talks about the fact that the construction manager will provide a preliminary evaluation of the owner's program schedule and the cost. And then the construction manager in consultation with the owner and the architect shall provide recommendations with regard to acceleration, fast track scheduling, procurements, for example, long lead items and when they need to be ordered, sequencing and phase construction. So there's an opportunity early on for having a dialogue between the parties as to, fundamental delivery approaches as to, getting this project, delivered in the most economical and efficient ways possible. Well, this deals with the digital tools. Mike and I spent most of many years together talking about building information modeling and other digital tools. And that process is still evolving. And basically, what we want to see in a collaborative approach is more collaboration with respect to the use of digital tools. Digital tools can reinforce the collaboration process, but it requires parties to understand how to use those tools and understand how to collaborate with one another. The fact that the tool can help in collaboration doesn't make it so. Parties have to still, work together to accomplish that collaborative undertaking. And so, again, the CM is supposed to work with the owner and the architect to establish the various written protocols for the use and the transmission, and that is just, again, a re-emphasizing of the fact that that the parties need to communicate and understand what their shared interests and goals are. This is that page by page review process, and the committee was quite adamant that setting forth a process whereby everyone gets into a room or whatever. These days you don't have to actually get in the same room anymore. You can do these reviews electronically, but together working through and having a good understanding of what the overall process is, and there's nothing better to do that than go page by page with regard to the evolving design. So this happens to be the schematic design documents, but that process works its way through the entire design phases. Okay, let's talk a little bit about incentives. One of it's a misnomer to believe that the traditional documents don't have incentives in them. Every contract creates incentives, because if you create a document, then you are automatically, or an agreement, if you're creating a document that results in an agreement between the parties, the fact that those parties have entered into an agreement creates various incentives. One is that the breach of that agreement can result in damages. So you don't really need to draft anything in the agreement that says something about the incentives. The fact that you have an agreement in and of itself creates certain incentives. By and large, those incentives are disincentives. They're not necessarily, written in a way to encourage you to do something because something good is going to happen to you. It's more or less, it discourages you from doing something bad because something bad is going to happen to you if you do. And so what, these documents try to do in a collaborative approach is to de-emphasize, or rather emphasize more greatly, positive incentives rather than negative disincentives. And so one of the more common incentives is the sharing in any expected cost savings. That's the most straightforward incentive that you can create in the context of this particular model. Now, sharing has been an incentive over the years with regard to the CM at-risk document, but it's never been emphasized. And as a general rule, owners don't really, look forward to sharing any cost saving. Their overall approach is, well, that's your contract, that's what you're supposed to do. So if you actually get the work done a little earlier, well, kudos to you, but there's no real incentive other than the fact that I slap you on the back and say good things about you. Well, here there's an opportunity to actually become more invested in those incentives. And so, there's an opportunity to discuss that, but they are not like the incentives in an integrated project delivery approach, which frankly, the incentive provisions in the IPD documents get very, very complex. And it's been, essentially a hurdle to parties being able to use IPD documents. This is a fairly straightforward incentive program. And as a result, we expect that these documents won't encounter the same kind of resistance that we saw with regard to the IPD documents. Dispute resolution. Well, the hope is that through collaboration, you don't get to disputes. That's the hope. The reality is that, construction, tends to result in unknown conditions that tend to result in disputes for a variety of reasons. It just so happens that, a lot of lawyers like myself have educated our children based on the fact that it's difficult sometimes to get things built without having disputes. But there's a collaborative way of going through dispute resolution and a non-collaborative way. And I will guarantee you, having practiced law for 40 years, it's much cheaper to resolve disputes collaboratively than it is in an uncollaborative or non-collaborative manner. So the process here is, well, how do we develop a program and a process that encourages the parties not to lawyer up right at the start and all of a sudden end up in this, kind of nuclear war with regard to their dispute. And part of that is essentially a meet and confer obligation. It means that first off, it's the project management team that tries to resolve disputes at the project level. Because what we've discovered through the years is that the parties most knowledgeable about the dispute are the parties closest to the dispute, and those parties are probably the best able to resolve the dispute equitably. But if that doesn't happen, then the next result is not to hire the lawyers, but rather to move that up the chain of command within the various organizations and have those parties meet and confer and have real, real meaningful discussions about how to resolve their disputes. And so those meet and confers are confidential, and they hopefully will result in an overall resolution of the dispute. If that's not possible, then you go to the next phase, which is mediation, and then through mediation, you go through a formal dispute resolution process, either arbitration or through litigation. But so we've added an extra step, but we think that that extra step is is meritorious given the collaborative nature of the overall agreement. I think I'm done. Okay, turn it over back to you.
Yeah, yeah, you're done. You can go now. Um, Thank you for that, Pat. And I just wanted to reiterate a couple of things that were really one thing, and that is the idea that the more integrated and collaborative process. So we still have a dispute resolution provision. There still will be disputes. It's going to happen. But anybody who's been on it doesn't even matter if the contract had collaborative provisions in it. Anybody who's been on a project where the parties worked well together and collaborated can probably testify to the fact that there were fewer maybe disputes or disagreements that couldn't get worked out throughout the collaboration process. And so infusing the documents with what Pat called organic collaboration opportunities is in and of itself should help alleviate some of the caustic nature of construction projects, hopefully to set the project up better for success. And even if you do get to disputes, that they can be resolved in a much more amenable and quicker and cheaper fashion before the lawyers get involved. Hence the initial meet and confer obligation in these documents. So anyway, with that, we'll move on to the last section of this presentation. And so we've talked a lot about the collaborative nature and the collaborative elements that were added into the CM documents to make our collaborative CM delivery model. And I went over how the structure of a CMC family of documents really lends itself to being able to allow the parties, all three, owner, architect, and contractor, construction manager, to collaborate throughout the design process. But that's not the only, it's not that you can't have more collaboration on other delivery models as well. And the industry is working towards trying to find ways to facilitate more collaboration, even if you are in a delivery model different from a CM setup. So one of the things that's happened in the last few years is the AISC, the American Institute of Steel Contractors, reached out to us and asked if we'd be interested in collaborating on a white paper to help to define certain types of collaboration that can happen on any project. Generally, informal involvement, design assist, and delegated design. These are all types of ways that usually contractors can be involved in the design of a project. And some of them can happen very early on. Some of them necessarily have to happen after the design's been done. But they're all efforts to increase levels of collaboration. The problem that was presented by AISC for our two groups to work out was, well, how do you define these things? These terms like informal involvement and specifically design assist were being used in the industry, but there was no real understanding about what each of them meant, and no way to bracket them in terms of what services they entailed. And so we undertook with them drafting of a white paper, part one. And unlike mine and Pat's IP article, there is a part two of this. I believe it's in the final stages. I'm not sure if it's been published yet, but in any event, this one was an attempt to, in a broad base way, define the differences between delegated design, design assist, and informal involvement. For each of them, there's a different level of responsibility that's associated with the type of assistance that's being provided in the design. So informal involvement, we'll have definitions of each of these on the screen, but informal involvement, the white paper, to put brackets around it, just define it as really just informal exchange of information between a design builder and a design professional and a contractor. And there would typically be no agreement associated with this. So this is happening early on in a project. If you think in a design bid build type of project where there's no contractor yet because the project hasn't been designed and hasn't been bid yet, This would be a scenario where an architect probably reaches out to a contractor they've worked with in the past to get some initial takes on some design concepts that they're considering. So it's an uncompensated, it's really an advice of friends, almost no compensation. But along with that, there's no expectation of responsibility from the contractor for the advice they're providing. It is much more of a friendly offer of advice that the designer will then take into consideration as it further develops the design for a project. So if you think about all this collaboration, these types of collaboration on a spectrum, informal involvement would be the beginning of the spectrum. Next along the way is design assist. And this describes a form of collaboration where the contractor provides a more formal type of advice. They're providing information to assist the design professionals design, but before it's priced, before you have a bidding process or a GMP amendment being executed. And there may ultimately be that contractor may ultimately be on the project, but that would be under a separate contract with the owner. The contractor may, but this is because it is a more formal type of advice. There would be a expectation that the contractor might actually have some contractual liability for the information it provides, because the design professional is now relying on that information. That doesn't mean that the design professional is not still responsible for the ultimate design, but there is an expectation that the information the contractor provides will be relied on by the design professional. So if you compare it to the informal involvement, it's a more formal relationship between an architect and a contractor. And then the last stop on the spectrum. Actually, I forgot to mention that we did develop a standard form agreement for design assist services. And again, this goes back to the purpose of that white paper, which was to, what we do is we write standard form agreements to sort of crystallize standard practices around certain delivery models or certain practices. And so having defined what design assist services primarily consist of and how the responsibilities for those services fall between the client and the consultant, we developed an agreement to reflect those standard practices. So the C403 is a standard agreement for design assist services. Now that takes us to delegated design, which is the last stop on our collaboration spectrum. Everyone is probably familiar with delegated design. This is when you typically have contract documents developed by a designer, but there are elements of the project that are delegated to the contractor to complete the design. And these are reflected in our standard A201 language. But again, somebody's got to be hired to provide those delegated design services. So we did do an agreement to reflect those standard services. But what's on the screen now is the standard language in A201 defining the delegated design responsibilities. And I won't read the whole thing on the screen, but anybody who's familiar with A201, it's 31210. And the responsibility from the design professional is to essentially specify all the performance and design criteria that the design services that are going to be provided by the contractor must satisfy. And then the owner and the architect are entitled to rely upon the adequacy and accuracy of the services, certifications, and approvals performed by the contractor's design professionals. So that sets out again the level of formality and expectations between the two parties. And then that's going to be reflected, a little heavy-handed on the buttons there. That's going to be reflected in the C404. So we have a standard form agreement for those. Now these are for the contractor to hire its delegated design consultant. And essentially, these are developed based on what we have in the A201. So we have our delegated design documents, we have our design assist documents, and we are also, to tip our hand even further, we're in the process of revising our design build family, and that we expect to include and a version of design build that will be a more collaborative version of design build, implementing progressive design design build principles. So to help enhance the design portion of design build. So we'll have another program on that in the near future. I'm almost certain. So so with that, we have about 5 minutes left. So if there's any questions, Hasi, you can let us know. In the meantime, though, you will all receive this PowerPoint and has links to our ACD Learn site as well as our help pages. We have a YouTube channel with a number of videos and other education programming you can take a look at and see if there's anything you're interested in. And then we have a construction risk brief, our monthly newsletter. And obviously, if you have any questions about our documents, we have our email and telephone number there for you to give us a call. So with that, our formal presentation is done. And Hasi, if you've got any questions for us, we'll do our best to answer them.
Thank you, Mike. We do have a number of questions, so let me go ahead and get started. How does IPD affect the traditional RFI and change order processes? Are there different forms?
Well, we never published different forms for the change. Well, we never did an IPD set of change order forms. I think the expectation underlying IPD is that there will be very few, if any, change order forms. Our IPD documents were published in 2008 and 2009, so my recollection of the change order provisions in those is a little fuzzy at this point, but we never developed separate forms for them. My recollection is that if there was a necessary, if you're in a three-party agreement and you needed to change the requirements for the project, you'd have to do an amendment where all three parties would sign it, which in a way isn't so different from a traditional change order. But we don't have separate forms for IPD change orders. Pat, any additions there?
Well, I mean, you know, the construction process documentation isn't changed. So from that standpoint, we would still expect an RFI. The actual information exchange may be different because in an IPD arrangement, you have an operating team, and that team arguably could avoid a lot of RFIs because the communication process is more organic. So I would expect that there would be less need for an RFI, but the documentation process in an IPD project, particularly during the construction phase, isn't radically different.
And I think that holds true for these collaborative CM documents. I mean, the concepts of an RFI and a change order are still in those because they're based on our traditional CMC documents, which are also based on our A201 in terms of their backbone. But going back to avoiding disputes, and I think avoiding or having fewer RFIs and change orders, I think the collaborative process that occurs throughout the design before the GMPs are set the processes are still there, but I think the frequency in which they would be implemented would be fewer.
Yeah, I think it would be a good management process. Yeah, at the end of the day, yes, you're communicating more collaboratively, but there must be, there must be project documentation that's created, so to reflect, for example, decisions that are made in that collaborative process, and whether those take an RFI and in a response to RFI or supplemental instruction, that documentation isn't supplanted merely because you're collaborating as a team.
Okay, and then how will the CMC documents be rolled out to contractors?
The same way any of our other releases, if you are a software license holder, when the documents are released, which I don't have a hard date on yet, but in the near future, when the documents are released, you'll get I think they'll appear in your templates. If you are buying our documents on a one-off basis, they'll just be available in the online store as a new template to purchase. They're the A1, just keep track. They're the A135 and B135 documents. So just be on the lookout for them, and I'm sure there'll be some marketing emails going out your way at some point in the near future as well. To hopefully you won't miss them. But if you want to keep coming back to our website to find out more information on the upcoming release, then that's another good way to find out. But it'll be our normal process of making them available through our software and DoD Plus platforms.
Okay, and with that, unfortunately, we are out of time. Please feel free to send any additional questions through our docinfo. If you'd like some answers, we can get you connected with any answers to the questions. Thank you to our presenters for this comprehensive presentation. Just a reminder to attendees that you will get the recording and the PowerPoint emailed to you. So with that, thank you all for joining us.